Strap in, because this is part 2 of our deep dive on Section 9 of the OGL, which specifically deals with updates to the OGL and how they are applied. Let's specifically address the topic of backpropagation of new updates to previously published works published under an earlier license. Now, the additional confusion seems to be coming from the fact that, well, since, hey, you can use any authorized version of this license to copy, modify, and distribute any open game content originally distributed under any version of the license, that this somehow means that any version of the license that Wizards of the Coast would want to write automatically applies to any other work or all works that have published under any version of the license. And that's not true. It says that you may use any authorized version of this license to copy, modify, and distribute any open game content license originally distributed under any version. It does not say that all authorized versions of this license apply to all works that have been released under any version of this license. That's not true, and that's also, again, getting at the very core of the problem that we are having with Wizards. When Mark published this book, he agreed to 1.0a. He took that particular license. If there had been multiple versions of the license, he could have selected whichever one that he would like. There is only one, so we use that. Mark agreed to 1.0a and its terms when he wrote this book and put it out under it. If Wizards of the Coast writes version 2, is Mark at all a party to version 2 because his book is published with version 1? And that's not true. No, it is not. Because you can at least posit a hypothetical where multiple versions of the OGL might even be mutually exclusive. They could not exist together. So why would it make sense for multiple versions of a license to be simultaneously licensing the same work? Maybe they are if the publisher agreed to them. We just gave an example about how this book could be released under version 1 and version 2 with the reprinting, but it doesn't make sense that without the publisher's authorization that all of a sudden a new license applies to it. That's what Wizards of the Coast was trying to do with version 1.1 draft, saying that, well, because you agreed to version 1.0, then if you still have any books on the shelf or on a PDF or something like that that's available to the public with version 1.0a in it after a certain date, you are automatically now a party to version 1.1. And that is not the way that it is. And that's a great thing because it keeps, like Wizards of the Coast, from doing something draconian or at least enforcing something draconian on someone, like they were about to do. Because you go, no, 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 no. I am not a party to 1.01. I did not publish this book under 1.01. Not at all. 1.0a is in the back of this book and I agreed to it. So that's great. Some people are positing a hypothetical scenario where what happens if they were trying to do something nice for you, like keep the exact same license, but put the word irrevocable in there. Well, in that case, they're trying to do something nice, but it still doesn't matter. The principle is the same. You published under one license. You chose what license to publish under. When you published your book, they cannot apply a different license to that work, right? They can't do that without your permission and you're agreeing to it, even if it's a great license. If it is a great license, then you know what you can do? You can republish and re-release your work under that license. So I do not believe this at all means that this backpropagates, a new version backpropagates and applies to your work and you're now a party to it. That's not true at all. No one would have accepted that when this was drafted because they would realize that if somebody writes something else, just because WotC is in a dark room, some executive writing a new version of the license that says something like, if you published under a previous version of this license also applies to you. There's no way that something like that could have gotten into this license because that would be way too easy to abuse. I mean, that would have been one of those red flags that people would instantly have noticed. Hey, wait a minute. If some WotC executive in a dark room starts typing up a new version of the license and publishes it out on the WotC website and then tries to claim, hey, now all that work that was published under a different license and people agreed to this license, you're now automatically agreed to this license. And hey, part of the terms of this license is the rights to everything that was published under a previous version of the license is now irrevocably transferred to Wizards of the Coast on a worldwide, perpetual, and royalty-free basis. Ha-ha, we've got it all now. No, that doesn't work at all. That does not work at all. Nothing like that would backpropagate to something that you did not agree to, right? You agreed to a certain license when you published. Likewise, final thing here, there seems to be some misunderstanding as well about whether or not you needed to agree to the license and whether or not that is relevant. And I'm arguing that is not relevant. It may be relevant going forward, so it's an important discussion to have about how we may use these licenses in the future. That's a very important discussion to have. But, for instance, let's say in a hypothetical scenario, you published a book that did not need the open gaming license. Now, in this case, you may want to put the open gaming license in it because you may want to identify certain parts of your work that you created that you want to give to the community, right? And say, hey, you can use this in the spirit of open gaming, like Mark did. These new character classes, these new magic items, whatever it is, I'm going to use the open gaming license because I want to designate that material as open content that the world can use under the terms of the OGL. So you may want to. If you're trying to make your material open content for other people to use, you may want to use the SRD, you may want to use the OGL. That's what the OGL is there for. That allows you to do that. But let's say that the only reason you wanted to use the open gaming license is because you wanted to use the SRD. But let's say that the only reason you put the OGL in the back of your book and published under that license is because you thought you needed to. But now, with maybe some kind of different analysis, maybe you did that 10 years ago, but now today, you and your lawyers and IP people and everything sat down and went through your book and realized, you know what? You don't actually quote from the SRD in here, because that's what the OGL allows you to do. You may quote from the SRD, right? You can, which ordinarily is a copyrightable document. Remember, the game mechanics themselves are not copyrightable, but the expression of game mechanics are. The SRD is an expression of game mechanics that is absolutely copyrightable, but that you may absolutely copy from under the terms of the OGL. That's what it allows you to do. But maybe you go through here later and you go, you know what? I didn't actually quote from the SRD. There's nothing in here that I actually drew from that I needed to use the SRD from. Maybe I just used my own language. I still talked about game mechanics, but I expressed them in my own way. You know, Dungeons & Dragons game mechanics, but I expressed them in my own way, etc., etc. So, and also, no, I didn't release anything as open game content. It was just all mine. I'm just going to hold the copyright to everything just to myself and not license it out. And so, hey, you know, turns out I didn't even need to use the OGL. I did not need to put the OGL back here. That could completely be true. And you know what? In a court of law, a Wizard of the Coast attorney could say, we completely agree, Your Honor. There was absolutely no reason for this other person's work to have been published under the OGL and acquiesced to the terms of its license. It was not necessary at all. That book could have absolutely been published without it. But it was published under it. I can hold it in my hand. I'm holding it in my hand. The back of the book has the license in it. I'm looking at it, Your Honor. Submitted as evidence. This work was published under the OGL. It's not relevant that it didn't need to be. That's irrelevant. What's relevant is that it was. And so that's why we've got to determine the legal status of the material that is in this book, because it was published under it, regardless of whether or not it should have been. All right? That'll change things going forward. It's not changing what is actually published and out there under the work. And this becomes especially relevant if something like the back propagation of updates is what Wizards of the Coast is trying to pull. Because they could say, you're right, there was no reason for you to publish your world using the OGL. You did not need to, but you did. And then we updated the OGL to say that anything published under a previous version of the OGL now belongs to us. And that's absolutely wrong. And everything about that is wrong. And that's why it's unbelievable that Wizards is even trying. So that's a continuation of that discussion and more evidence, I believe, as to why the position the community needs to hold to is that Wizards of the Coast must acknowledge that 1.0a of the Open Gaming License cannot be deauthorized and cannot be revoked. But wait, using this mechanism, did we accidentally back into exactly what we wanted after all? Is there a way using this mechanism that if Wizards of the Coast put out an update to the OGL that was the same as the first version, but that it was irrevocable, is there a way to use this mechanism to do what we wanted? That's in part 3.